I've handled thousands of lawsuits in my 34-year practice here in Albuquerque, and one of my favorite cases and favorite clients was Stella Liebeck, a 79-year-old woman who had just moved here from Tucson to be near her family, and she and her grandson purchased a cup of coffee at a McDonald's here in Albuquerque one morning, and they pulled over in the parking lot so that she could, and stopped so that she could take the lid off of the coffee and put some creamer in it. Unfortunately, it spilled in her lap. She was in a jogging suit, and it just absorbed that coffee almost immediately, and she couldn't get away from it. It was almost like an immersion burn. And long story short, in that 3 or 4 seconds, she suffered third-degree burns to her crotch and groin area that required 2 skin grafts and 8 days in the hospital. And she had never been in court before. She's just hard work.
Attention, accident victim. If someone, somewhere owes you big money, it pays to hire a heavyweight. I'm Lowell, the Hammer Stanley. 459. I'm the avenger for the injured, the mistreated, the ignored. I do more to get you more. Get what's yours. I've been hammering for victims for 30 years, and I'm just getting warmed up. I hammer stingy, greedy insurance companies for victims like you. I will punch them, pound them, punish them, pound. You don't want to see it done. And let's talk about size. Size matters. And let's talk about size. I will hammer them. You don't want to see it done. Hammer them.
Hello, I'm Randy Fife, an attorney practicing in Steptoe & Johnson's Charleston, West Virginia office. Today, I'd like to speak with you about West Virginia's joint and several liability law. First, some history on the West Virginia rule. Prior to 2005, if 2 or more defendants were found jointly responsible in negligence to a plaintiff, the plaintiff could recover an entire verdict against just one of the defendants. This would mean that if your company were found to be 1% responsible to a plaintiff, and another company were found to be 99% responsible to the plaintiff could recover the entire judgment against you. In 2005, the West Virginia legislature modified this joint and several liability doctrine. It essentially created 3 categories of defendants depending upon the percentage of fault allocated by a jury. In the first category, defendants are allocated less than 10% of fault. In the second category, defendants are allocated more than 30% fault. In the final category, defendants are allocated from 10 to 30% fault. In the first category, where defendants are allocated less than 10% of fault, the defendant will never be asked to pay more than the percentage allocated, regardless of whether the co-defendant can pay. In the second category, where defendants are found to be more than 30% at fault, the traditional rules apply, meaning that a defendant found, for instance, to be 35% at fault may be asked to pay the entire judgment if a co-defendant can't pay. In the final category, where a defendant is found to be between 10 and 30% at fault, a defendant's liability is generally civil, meaning they only have to pay the allocated percentage. However, if the co-defendant can't pay, a judge may ask the paying defendant to pay more. Let's take an example to understand this complicated category. In this example, let's say a jury awards a plaintiff $100,000 in damages and allocates 25% fault to one defendant and 75% fault to another defendant. If the 75% defendant can't pay, then the judge may require the paying defendant to pay its 25% plus 25% of the remaining $75,000, which has gone unpaid. One note, however, if the paying defendant's percentage of liability is less than or equal to the plaintiff's percentage, then he need not pay any additional amount. As with everything, there are exceptions to West Virginia's modified joint and several liability law. It does not apply in cases of toxic torts, intentional torts, strict liability for manufactured products, or where 2 or more defendants are acting in concert with each other. 3 other points are important to remember in joint and several liability cases in West Virginia. First, a plaintiff who is found to be 50% or more at fault for his own injuries cannot recover from any defendant. Second, a settling defendant is generally, in most cases, exempt from contribution from its co-defendant that doesn't settle. Third, a jury should always be asked by questions to allocate fault. Otherwise, defendants are required to pay a pro rata share of the verdict. I hope you have found this information useful. The intricacies of joint and several liability law are extremely important to understand when crafting a defense strategy, and the rules vary from state to state. Please feel free to call me or any litigator at Steptoe and Johnson to help you navigate through this or any other area of the law. Thank you.
Pat, thank you. Well, now that you have all your new employee paperwork signed, let's get you started on some cases.
I'm really looking forward to working with you. Where do we start?
Let's spend a little time reviewing the basic elements of a negligence case. As you know, we represent a lot of car wreck cases, medical malpractice cases, and some legal malpractice cases, which all involve some form of negligence. So, let me ask you, what are the basic elements of a negligence case?
Duty, breach, causation, and damages.
Very good. You obviously studied this in school. Let's pretend I don't know anything about a negligence case. Let's review the basic elements. Start with duty. What does that mean?
A duty is a legal obligation one person owes to another. Before you can have a negligence case, you have to prove that the defendant owed a duty to the plaintiff.
Wouldn't we all owe duties to everyone?
No, actually, there's a lot of situations where one person doesn't owe a duty to the other. So if they fail to act, there couldn't be a civil case for negligence. You first have to establish what the duty is and then prove the second element, which is breach.
Okay, tell me about breach.
Well, once you've established that the defendant owed a duty to the plaintiff, then you have to prove that the defendant breached that duty. All these elements build on top of each other. If you don't have duty, you don't have a case. If you have duty but the defendant didn't breach it, you don't have a case.
How do we prove the defendant breached the duty?
We show he acted improperly or negligently. Violating the standard of care for a doctor is one, or showing that the defendant acted recklessly is another. If the defendant's a motorist, for instance, and he violates the rules of the road, it's a great way to prove breach.
Okay, so far so good. Tell me about the third element of a negligence case.
Causation, which is a tough one because in civil cases you have to have proximate cause.
And what's that?
Proximate cause is proof that there's a direct factual link between what the defendant did or failed to do and injury to the plaintiff. You really have to have a strong connection between the two for a jury to find the defendant liable to the plaintiff.
Give me an example.
Okay, say this guy runs a red light without stopping. He hits our client. We have duty because all motorists owe a duty to all other motorists to obey the rules of the road. The guy breached the duty by running the red light, and his failure to stop is a direct connection to injury suffered by our client.
Okay, tell me about the fourth element.
Damages. Once you've proven the first three, then and only then can you find out what the client's injuries are. You can ask the court to force the defendant to pay for things like all medical expenses related to the accident and lost time from work, pain and suffering. And the one I can never remember where the spouse files to.
Loss of consortium.
Yes, that's where the spouse files a suit against the defendant for causing injury to the husband, and because the husband is injured, he can't perform the same activities he'd be able to before the accident.
That's pretty good, Pat. What can you tell me about special